Registration Act 51 of 1992. This section regulates the amendment of the forenames and surnames of South African citizens and is linked to Regulation 18.2a of the Regulations on the Registration of Births and Deaths, 2014. The regulations provide the legal framework for individuals to apply to change their names. The High Court declared Section 26(1)(a) to C unconstitutional on the ground that it discriminates on the basis of gender. In this court, the applicants seek confirmation of the declaration of invalidity in terms of Section 1675 of the Constitution. The first applicant is Ms. Jana Jordan, who was married to the second applicant, Mr. Henry van der Merwe. The third applicant is Ms. Jesse Donnelly Boorman, who is married to the fourth applicant, Mr. Andreas Nicholas Boorman. The first and second respondents are the Minister of Home Affairs and the Minister of Justice and Constitutional Development, respectively. In the case of the first and second applicants, prior to their marriage, they had agreed that the second applicant would assume the surname of the first applicant in order to preserve her familial ties to her deceased biological parents. Upon registration of the marriage, the first and second applicants were advised by the Department of Home Affairs that it was not possible for the second applicant to assume the first applicant's surname. The first and second applicants also have a child who they would like to bear the surname Jordan. Excuse me. In the case of the third and fourth applicants, the third applicant wished to retain her surname to preserve familial ties with her biological parents as an only child, and the couple intended to have their surnames reflected as Donnelly-Boorman. They were advised by the department that only a female spouse may amend her surname, not a male spouse. The applicants instituted proceedings in the High Court in which they sought, among others, an order declaring the impugned provisions of the Act and regulations unconstitutional to the extent that they discriminate on the grounds of gender. They also sought ancillary relief regarding the assumption of their preferred surnames. The respondents did not oppose the matter in the High Court. At the request of the High Court, the Free State Society of Advocates was admitted as amicus curiae, that is a friend of the court. The High Court declared Section 26(1)(a) to C unconstitutional to the extent that it discriminates on the ground of gender. The High Court further held that Regulation 18.2a is unconstitutional to the extent that it discriminates against male persons by failing to provide for a man to apply to change his name following a change in his marital status. In the interim, the High Court ordered a reading in terms of which reflecting that both men and women may apply to change their surname, and that until new regulations are passed, the reasons given for changing one's surname referred to in Section 26(2) of the Act must relate to a change in the marital status of a person. The High Court granted further relief and amended the surnames of the applicants to their desired surnames. In this court, the applicants submitted that the impugned provisions are patriarchal, discriminate on a prohibited ground, and cannot be justified in an open and democratic society. The first and second respondents filed notices of intention to abide. Pursuant to directions issued by the Chief Justice, the respondents were directed to file written submissions, specifically addressing the relief sought by the applicants. The respondents agree with the applicants that the impugned provisions are rooted in colonialism and patriarchal norms. The court considered the following issues: the constitutionality of Section 26(1)(a) to C of the Act, the constitutionality of Regulation 18.2a of the regulations, and the appropriate remedy. In respect of the constitutionality of Section 26(1)(a) to C of the Act, the court begins its analysis by examining the historical context of women assuming their husbands' surnames after marriage. This court considers that this practice is largely a colonial import, rooted in patriarchal norms, where women were seen as legally inferior to their husbands and expected to assume their identity. The court then considers the right to equality and the two-stage test laid out in Hoxton versus Lane. The court finds that the inability of men to assume their wives' surnames constitutes differentiation. Under the current scheme regulating names in terms of the impugned provisions, spouses are not granted the same freedoms, and this is based on gender alone. Next, the court considers whether the differentiation serves a legitimate government purpose. In 1992, the current Act introduced provisions to regulate the assumption of a surname from the time that a birth is registered. In general, the objective of regulating surnames is to ensure that new surnames are not created which bear no connection to the family. The legitimate government purpose in this case, namely seeking to regulate surnames to ensure that new surnames are not created which bear no connection to the family surname, is not served by the differentiation. This is because the restriction imposed on assuming another surname is not removed if the differentiation is remedied. Persons wishing to change their surnames may only assume an existing surname, namely that of their spouse. Thus, the differentiation serves no legitimate government purpose. As to whether the differentiation constitutes unfair discrimination, this court finds that the discrimination negatively affects both men and women. In the case of men, they are deprived of the ability to assume their wife's surname if they so wish. In the case of women, the effects of the scheme are far more insidious. It is not merely so that they are deprived of the right to have their surnames serve as the family surname where their husbands wish to take that surname. It also reinforces patriarchal gender norms which prescribe how women may express their identity, and it makes this expression relational to their husband as a governmental and cultural default. The court further considers the factors posited in Harkson to determine the extent and impact of the discrimination. The court recognizes the nuanced and multifaceted impact of patriarchal norms. The inability of husbands to assume their wives' surnames removes their right to make choices pertaining to their own identity. Further, it prevents them from determining how to structure their familial unit. The impact on women is also far-reaching. The symbolic consequence is that women's identities are subsumed into their husbands' families after marriage. This has the inevitable upshot of entrenching the notion that the husband is the head of the household. This practice also perpetuates the historical philosophy that women are not equal to men and become akin to minors upon marriage. The court further finds that this limitation of equality cannot be sustained under Section 36 of the Constitution. On whether Regulation 18.2a is unconstitutional, this court finds that it is not necessary to confirm the order striking down the regulation. This court contextualizes its analysis of unconstitutionality with reference to international and foreign law. The court finds that the International Covenant on Civil and Political Rights supports one's ability to assume a surname change without regard to gender. There have also been similar cases considered by the United Nations Human Rights Committee and the European Commission of Human Rights. The findings of both of these fora support this court's conclusion relating to gender-based discrimination and the infringement of the right to equality. In respect of remedy, this court considers the appropriateness of a suspension order. It finds that a suspension order is required and necessary to allow Parliament to make the provisions constitutionally compliant and to preserve, in the meanwhile, the regulatory framework that permits, albeit deficiently, spouses upon marriage to change their surname. This court orders an interim reading-in remedy during the period of suspension. The applicant sought a reading-in of masculine pronouns to remedy the defect in the interim. However, to ensure that the reading-in remedy does not cause further discrimination on the basis of gender, this court employs the language of the Civil Union Act. The Civil Union Act refers to persons, partners, and spouses rather than men and women or husband and wives. This language not only remedies the constitutional defect that exists by unfairly discriminating on the basis of gender, but accords more with the Constitution because it is inclusive of all identities. The applicants also sought an order the first and second applicants also sought an order directing the first respondent to amend the surname of the first and second applicant's child to Jordan. This court finds that no case was made out in the High Court or in this court why this relief should be granted. The declaration of invalidity in this matter pertains to the violation of the right to equality on the ground of gender in the specific context of marriage. It cannot follow as a matter of course from this declaration of invalidity that a child whose surname is determined under a different provision of the Act may have their surname changed following such declaration. Accordingly, the first and second applicants will be entitled to apply to the Director General to change their child's surname as provided for under Section 25(2) of the Act. In respect of cost, this court finds that it is appropriate for a cost order to be awarded against the first respondent. Despite the fact that they did not oppose the confirmation on its merits. This is because, but for the constitutionally defective provisions, the applicants would not have had to bring this litigation to vindicate their constitutional rights. The court makes the following order. 1. The order of constitutional invalidity issued by the High Court of South Africa, Free State Division, Bloemfontein, is confirmed. 2. Section 26(1)(a)(c) of the Births and Deaths Registration Act 51 of 1992 is declared unconstitutional to the extent that, in violation of Section 9(1) of the Constitution, it violates irrationally on the ground of gender, and to the extent that, in violation of Section 9(3) of the Constitution, it unfairly discriminates on the ground of gender by failing to afford a woman the right to have her spouse assume her surname, failing to afford a man the right to assume the surname of the woman after marriage, failing to allow for a married or divorced man or widower to resume a surname which he bore at any time, and failing to allow a man, whether married or divorced, or a widower, to add to the surname which he assumed after the marriage any surname which he bore at any prior time. 3. The declaration of invalidity is suspended for a period of 24 months to enable Parliament to remedy the defects by either amending the existing legislation or passing new legislation in order to ensure that all persons are afforded the right of assumption of another surname. Pending the coming into force of the new legislation or amendments to existing legislation designed to afford the right of assumption of another surname as set out in Section 26(1) of the Act, it is declared that the provisions of Section 26(1) shall not apply when a person after marriage assumes the surname of the spouse with whom such person concluded a marriage, or after having assumed such surname, resumes a surname which they bore at any prior time. B. A married or divorced person, or a widow or widower, resumes a surname which they bore at any other time. And C. A person, whether married or divorced, or a widow or widower, adds to the surname which they assumed after the marriage any surname which they bore at any prior time. 5. Should Parliament fail to correct the defects in the 24-month period, Paragraph 4 of this order shall continue to operate until remedial legislation, if any, is brought into operation. 6. The first respondent is ordered to pay the applicant's costs in this court, including the costs of 2 counsel where so employed. I hand down the judgment. Ms. Swart, this is where you say, as the court pleases. The court will rise.